The chair recognizes Senator Hawley for your question.
Thank you very much, Mr. Chairman, and thanks to all the witnesses for being here. Dr. Pylon, let me just start with you, if I could. Just help me understand the history here. My understanding is that the United States Justice Department, the Office of Legal Counsel, has weighed in on this question a number of times over the course of its history. To my knowledge, the Office of Legal Counsel has never said that Congress has the ability by statute to turn the District of Columbia into a state. Is that correct?
That is correct. The only exception occurred during the Obama administration when the Office of Legal Counsel gave the no-go for this. And so he turned to the Solicitor General's office, and the Solicitor General said, we can defend this. And of course, that's very precious because that's the job of the Solicitor General's office, to defend even unconstitutional matters that may turn out to be such.
Sure. So what happened was the Attorney General under that administration got a consistent answer, the same answer that Attorneys General had been getting and presidents had been getting for decades, decided he didn't like that answer and said, well, maybe somebody else will give me a different answer. But consistently, the Office of Legal Counsel, which is that unit in the Justice Department, that office that is charged with looking at these constitutional questions and providing dispassionate, impartial, nonpartisan legal counsel, has consistently said there's no constitutional authority for Congress to snap its fingers, use a statute to turn D.C. into a state. Now, tell me about this. Of course, that's a bipartisan tradition. You mentioned in your written testimony one pretty prominent Democrat Attorney General, Robert Kennedy. He rendered a fairly lengthy opinion on this. Tell us about the significance of Robert Kennedy's opinion back in 1963, I think it was, when he said that no, the Constitution does not give Congress the power by statute to turn D.C. into a state. Of course, it can be done by constitutional amendment. How exactly it would have to be worked out, but that's what we're talking about here. We're talking about just doing it by statute. Even Robert Kennedy said no, that can't be done. Tell us about the significance of his opinion.
Well, the significance beyond the fact that he was a Democrat comes from the fact that he said that this is a single act, the creation of the district. Then the question becomes, does Congress have authority to do what is contemplated by these various proposals that have come over the years? And the conclusion that the Office of Legal Counsel gave him was that no, they do not. It is a single act to create the district. It is finished. If you want to do something more like retrocession and so forth, you're going to need to find some authority under the Constitution. And the important issue here was just brought up by Senator Lankford, namely that this district is unique. It's not an ordinary process of creating a new state from territory acquired for the express purpose of creating new states from it, the Louisiana Purchase, etc. It is sui generis. It was created expressly under Article 1, not under Article 4, to be the seat of the federal government. Under this bill, S-51, the seat of government would be this tiny enclave, and I just invite you to think, in response to an earlier question from Senator Lankford, what this would mean with this much reduced authority of Congress to have exclusive jurisdiction over this tiny enclave. It means that, for example, they are dependent upon this new untested state for everything from power to water to fire protection, right, and going on and on. We can imagine how the framers did not want that, and they didn't want it expressly because of what the experience, as we testified earlier, they had under 1783 when the Congress was attacked by a mob.
Let me ask you this. So we have the scene set. The Constitution of the United States expressly and explicitly creates the District of Columbia. It designates it as the seat of government. We have the 23rd Amendment, which comes along and ratifies that, essentially. I mean, it's already in the Constitution. The 23rd Amendment ratifies that, so that it is there. It's not an unincorporated territory. It is created by the Constitution, created as the seat of government. Now, my understanding of constitutional law is Congress cannot, by legislation, override the Constitution. Am I right about that, basic understanding?
That's Con Law 101.
Now, what if Congress really, really wants to? Like, what if Congress thinks, no, it's really, really important that we override the Constitution? Do they get to do it then?
That's called the demise of the rule of law.
What happens if it's there's a great political advantage to one party if they do it? I'm looking here at a series of news articles from the last year and a half. The Nation. Democrats have inherited a broken Senate. Can they make it work? It calls for D.C. statehood to add 2 more Democrat votes to the Senate. NBC News. New push for Washington, D.C. statehood hits the presidential campaign trail. Imperative, Democrats say, to add 2 more votes to the United States Senate for them. New York Magazine. D.C. statehood is the Democrats' only option. Vox, 11 ways to fix America's fundamentally broken democracy. D.C. statehood to add 2 more Democrat votes to the United States Senate. Indivisible says making democracy reform a priority has to be D.C. statehood. All of this, the premise of all of these articles, which are very candid, is that Democrats think that they won't be able to control the United States Senate in the long term. They need to add 2 more Democrat seats to control the Senate, so it's really, really important. If they think it's really, really important, does the Constitution give them the authority to override what is actually written down in that text with a law? Can they do that?
Let me get on the record an important point. It is often thought that we on this side are opposed to giving the district residents the vote. Nothing could be further from the truth. The idea is, however, that you must do it in the right way. You've got to do it in the constitutional way. And so that means that you're going to have to address, among other things, the 23rd Amendment problem, because there will still be people within this district who still have the right to vote. You can't remove that from them by mere statute. It's got to have an amendment to do that. And indeed, if the tables were reversed on some other issue, I think the other side would be screaming if this were attempted.
And rightfully so. And I'll just finish, Mr. Chairman, by saying that it is a fundamental premise of our democracy that the Constitution of the United States is the supreme law of the land, that it binds all who live under it. And we, the people, can change it. We absolutely can change it. We have a process to do that, a democratic process. What Congress cannot do is override the Constitution anytime it becomes inconvenient for a majority in Congress, a temporary majority, as James Madison would have said. Today it's the Democrats, tomorrow it's the Republicans, after that the Democrats again, who knows? The point is the Constitution endures, and that is the fundamental premise of our democratic republic. And I fear that premise is being threatened by this legislation. Thank you, Mr. Chairman.
Thank you, Senator Hawley. I want to follow up on Mr. Pylon's comments on